Right now, sitting on the desks of 9 Supreme Court justices is a decision that could reshape how tens of millions of Americans vote this November. And as of today, that decision has not been made. If you've seen headlines claiming the Supreme Court already ruled on this, slow down because the actual case is still pending, briefing only closed this past week, and the outcome remains genuinely uncertain. What's actually happening is an emergency application asking the justices to let a presidential executive order restricting mail-in voting take effect just months before the midterms, over the objection of 23 states and the District of Columbia. This is exactly the kind of story where getting ahead of the actual ruling, assuming or claiming an outcome before it exists, does real damage because voters, election officials, and the Postal Service itself all need accurate information about what's actually in effect right now, not speculation dressed up as breaking news. I'm going to walk you through exactly what this executive order does, why lower courts have already split on it, what both sides are arguing to the Supreme Court right now, and why the compressed timeline before November makes this one of the most consequential pending cases in the country, regardless of which way it eventually breaks. Before we get into it, if you want to follow a genuinely live, unresolved Supreme Court case as it actually develops, not after the fact once the outcome is already old news, subscribe and turn on notifications right now. I'll bring you the actual ruling the moment it drops, whichever direction it goes, rather than guessing at it in advance. Let's get into exactly what's being fought over. Here is what the executive order actually does. On March 31, 2026, President Trump signed an order titled Ensuring Citizenship Verification and Integrity in Federal Elections. Among its provisions, the order directs the U.S. Postal Service to develop new rules for handling mail-in and absentee ballots, and instructs the Department of Homeland Security to compile state-by-state lists identifying which registered voters are confirmed U.S. citizens. Under the proposed framework, the Postal Service would be authorized to deliver mail-in ballots only to voters whose names appear on these DHS-compiled citizenship lists, meaning a voter not on the list could find their mail ballot never delivered at all. This is not the administration's first attempt at something like this. A related order from early in the year, addressing overlapping citizenship verification and ballot deadline provisions, had already been blocked by a separate federal judge in Washington state back in January, who found several of its provisions exceeded the president's constitutional authority, a ruling that gave both sides a preview of exactly the kind of legal arguments that would resurface in this new fight. A coalition of 23 Democratic-led states, plus the District of Columbia, led by California, sued in federal court in Massachusetts, arguing the order unconstitutionally attempts to dictate how states administer their own elections. The first segment is the specific constitutional argument the challenging states are making, because it's more precise than simply, "we don't like this policy." The states point to the Constitution's Elections Clause, which gives state legislatures, not the president, the primary authority to set the times, places, and manner of federal elections, subject only to Congress's power to override those rules by statute. Their core argument is that a president cannot use an executive order, which directs only his own subordinate agencies rather than going through Congress, to impose a nationwide framework governing how mail ballots get delivered, since that authority belongs to states and Congress, not the executive branch acting alone. U.S. District Judge Indira Talwani agreed with this reasoning on June 25th, issuing an order that blocked the federal government from implementing the mail-in ballot and citizenship list provisions in the 23 states and D.C. that sued, finding the states had shown a likelihood of success on exactly this constitutional theory. The second segment is what happened next, because the case took an unusual and genuinely confusing turn at the appellate level. The federal government appealed Talwani's ruling, and on July 25th, a divided panel of the First Circuit Court of Appeals in Boston upheld her injunction, with 2 Biden-appointed judges in the majority and a Trump-appointed judge partially dissenting, arguing some parts of the order should have been allowed to proceed. Just days later, a completely different federal appeals court, the D.C. Circuit, reached the opposite conclusion in a related case, ruling that this same executive order was not yet ripe for judicial review, since the Postal Service and DHS haven't finalized the actual implementing rules yet, meaning the challenge was premature. That D.C. Circuit panel included judges appointed by presidents from both parties, including 2 Obama appointees and 1 Trump appointee, all agreeing on the ripeness question even though they disagreed on other aspects of the case, which somewhat complicates any simple narrative about this splitting neatly along partisan lines. 2 federal appeals courts, reviewing essentially the same executive order, reached contradictory conclusions within days of each other, which is precisely the kind of unresolved conflict that typically forces the Supreme Court to step in and settle the question nationally, and it's part of why this case moved so quickly onto the court's emergency docket rather than following the slower, more typical path toward a full merits decision. The third segment is what the federal government is now asking the Supreme Court to do, and it's important to understand this is not yet a request to rule on whether the order is ultimately lawful. Solicitor General D. John Sauer filed an emergency application asking the court to stay, meaning pause, Talwani's injunction while the underlying appeal continues, arguing her order was extraordinary and flouts settled legal doctrines about when courts can intervene in a dispute before an agency has even finalized its rules. The government's position is fundamentally about timing and ripeness, that no one has actually been harmed yet because the Postal Service hasn't issued final regulations, and that courts shouldn't be blocking a policy based on speculation about how it might eventually be implemented. Notably, 12 additional states, led by Alabama, filed their own brief supporting the administration's request, pointing to the D.C. Circuit's contrary ruling as evidence the government's position has real legal support elsewhere in the federal court system. The fourth segment is what the 23 challenging states argued in their response, filed this past Monday, and their position centers on the practical stakes of getting this wrong just months before an election. The states argued that if the Supreme Court lets the order take effect now, it would allow the federal government to rush out what their filing called an unprecedented, legally indefensible voter verification and ballot interception program, warning specifically that citizenship verification systems commonly used for this kind of purpose are known to generate false positives, meaning eligible, legitimately registered citizens could be wrongly flagged and have their mail ballots withheld entirely. The states also raised a pointed logical challenge to the government's own position, that if the administration keeps insisting states aren't actually required to do anything different under the order, it becomes difficult to understand why the federal government is fighting this hard for immediate emergency relief, since there would be no urgent harm to prevent. The fifth segment is the timing pressure that makes this case unusually urgent, separate from the underlying legal merits either side is arguing. There are currently fewer than 100 days remaining before the November 3rd midterm elections, and the Postal Service itself stated in court filings that it is running out of practical time to implement the changes the president is demanding, even if the Supreme Court sided with the administration immediately. Election law specialists, including Derek Muller at Notre Dame Law School, have publicly stated that regardless of how the court ultimately rules on this emergency application, the sheer logistics involved make it increasingly unlikely the new rules could actually be implemented in time for this specific election, meaning even a win for the administration at the Supreme Court might not translate into real changes on the ground by November. The sixth segment is what happens procedurally now that both sides have filed their arguments. Justice Ketanji Brown Jackson, who handles emergency applications from the First Circuit, ordered the states to respond by August 3rd, which they did. The case can now be resolved in one of several ways. Jackson could act alone on a narrower administrative basis, though the core stay request will likely go to the full court for a decision. The full 9 justices could grant the stay, letting the order take effect while the underlying appeal continues. They could deny it, keeping Talwani's injunction in place. Or they could take some middle position, staying part of the order while leaving other provisions blocked, similar to how the lower appellate courts have already split. Let's step back and name what's actually at stake here, separate from predicting which way the court will rule. This case sits at the intersection of 2 real constitutional questions that don't resolve neatly in either direction. The Constitution genuinely does give states the primary authority over how they run their own elections, a principle with deep historical roots and real teeth in prior Supreme Court precedent. At the same time, the federal government genuinely does have some role in ensuring federal elections meet baseline legal requirements, and the administration's underlying argument that only confirmed citizens should be voting in federal elections reflects a policy position many Americans support, even if they disagree about whether an executive order is the right tool to enforce it. The fact that two different federal appeals courts reached opposite conclusions on essentially the same order tells you this isn't a case with an obvious settled answer waiting to be rubber-stamped. It's also worth understanding why the specific procedural posture of this case matters so much to how the Supreme Court is likely to approach it. The court isn't being asked right now to issue a final definitive ruling on whether this executive order is constitutional. It's being asked to decide a narrower, more technical question, whether the order should be allowed to take effect while the underlying legal fight over its constitutionality continues in the lower courts. Courts generally apply a specific framework for these kinds of emergency stay requests, weighing whether the party asking for the stay is likely to eventually win on the merits, whether they'd suffer irreparable harm without a stay, and where the balance of harms and the public interest lies. That means the justices could theoretically deny the stay while still believing the administration has a reasonable chance of ultimately winning the underlying case, or grant the stay while still having real doubts about the order's ultimate legality, since the emergency question and the merits question aren't quite the same thing. If there's one thing worth taking from this breakdown, it's that a pending Supreme Court case is not a settled outcome, and getting ahead of a ruling that hasn't happened yet in either direction does you no favors as someone trying to actually understand what's coming. This case could be decided any day now, and whichever way it breaks will shape how mail-in voting works or doesn't work for tens of millions of Americans this November. If this helped you understand what's genuinely at stake before the ruling drops, subscribe so you get the actual decision explained the moment it happens. Share it with someone who's seen the premature headlines, and I will see you the moment this actually resolves.